disposal is as first case item 4, second appeal 290 of 2017.
इसमें बोला गया था एक केस ला दिया गया था संग्राम बास्की लॉर्डशिप का ऑर्डर whether this case is similar to that case or for the purpose of remand the case. एक्चुअली संग्राम बास्की केस में जो होता था इसमें रिस्पोंडेंट अपीयर नहीं हुए थे और कॉन्टेस्ट नहीं किए थे. दिस ऑर्डर पास्ड विदाउट द कॉन्टेस्ट. एंड सेकंड थी
आपके पास कोई और जजमेंट तो बताइए.
हाँ, हम सारा जजमेंट दे रहे हैं. सबसे पहले बोला गया कि इसको आप देख लीजिएगा इस जजमेंट को, इसके बाद बताइएगा कि ये रिमांड का जो केस है सिमिलर है कि नहीं. इसमें हुआ था कि फर्स्ट अपीलेट को पॉइंट ऑफ डिटर्मिनेशन नहीं फ्रेम किया था और केस को डिसाइड किया. इन माय केस
पॉइंट ऑफ डिटर्मिनेशन हैज बीन
उसी ग्राउंड पे केस को रिमांड में किया गया. तो पॉइंट ऑफ डिटर्मिनेशन इन माय केस
वी हैव सीन द पॉइंट. और बताइए रीजनिंग को मीट किया है. रीजनिंग को मीट किया है. ट्रायल कोर्ट के रीजनिंग को एप्लीकेट.
हाँ, रीजनिंग डिस्कस किया.
लेट अस सी द रीजनिंग ऑफ द लर्नेड ट्रायल कोर्ट.
पैराग्राफ 30
पहले ट्रायल कोर्ट का रीजनिंग. Para 20 of the trial court judgment.
Page 21 of what say?
नहीं, page para 20 की का पढ़ी. Trial court judgment. Roman 6 is the bone of contention, correct?
ये मेन एग्जिबिट 4 के बारे में ये सेक्शन 64 जो डिस्कस किया है एग्जिबिट 2 उसी को हम पढ़ते हैं. सेक्शन 64 ऑफ द इंडियन एविडेंस है.
आप कहाँ पढ़े?
पारा 22.
पैरा 20 पैरा नेक्स्ट मतलब सेकंड सब पैरा.
That the case of the plaintiff with regard to his right, title, interest, and possession of the suit land is that one Ram Prasad Ram along with some others was settled land at measuring 5.84 acres within plot number 502 of Khata number 114 after reclamation by them, as the land was recorded as Garmajagua land in the last cadastral survey and settlement operation. Out of these 5.84 acre of land, Ram Prasad Ram was allotted 0.97 acre of land with specific boundary in amicable partition between the said lease.
So this fact is not in dispute.
Yes.
Yes.
Both the party claiming the land through Ram Prasad.
That's it.
Second, the case of the plaintiff hereinafter is that the father of the plaintiff also made effort in the reclaiming the suit land, and only because of his efforts Ram Prasad Ram and Phagu Ram entered into mutual partition among themselves, wherein Phagu Ram was allotted 0.56 acre of land, whereas Ram Prasad Ram kept himself only 0.25 acre.
Just a minute. This Phagu Ram is not related to Ram Prasad.
The Phagu Ram is the brother of Ram.
From where do I get this?
ये एविडेंस में हम देख लेंगे.
आगे बढ़ें.
Out of his share इतना एकड़, Ram Prasad Ram orally transfer 0.16 acre of land in favor of his daughter Kumar Kalia Devi, who by virtue of registered sale deed transferred the same in favor of the plaintiff. It is further been contended by the plaintiff that Ram Prasad Ram died without having any bail issue, and thus his interest in the suit land was transferred to plaintiff after his demise. and the remaining 0.16 acre of land was transferred in their favor by his daughter Murkalia Devi. In support of their contention, plaintiff had adduced oral as well documentary evidence. With regard to the
The
oral,
plaintiffs are son of Paguna.
son of Agra. In support of the contention, plaintiff have adduced oral as well as documentary evidence. With regard to the oral partition been taken place between Phaguram and Ramprasad, the plaintiff had produced the certified copy of partition deed bearing number 5653 dated in, which has been nomenclature as Basika Taksim Nama Bakhuda Exhibit 4. इसी Exhibit 4 पे आगे पूरा डिस्कशन होगा.
पढ़िए पढ़िए.
The contents of his shows that the father of the plaintiff, Phagu Ram, was allotted 0.5 acre of land, whereas Ramprasad Ram himself kept merely 0.25 acre. Whereas the entire land being allotted in favor of the Ramprasad Ram was 0.97 acre. But Exhibit 4 does not disclose anything about remaining 16 acre of land. It is the own case of the plaintiff that Exhibit 4 is the partition deed between two brothers, but from perusal of the same transpires that one brother got more than twice than other got, but no reason has been assigned therein of his discrepancy in allotted of the land between two portions. Further, the case of the plaintiff is that the Phagu Ram also endeavored in reclaiming the suit land, but they have failed to produce even a single sheet of paper in support of their contention. Admittedly, the land was settled in the name of Ramprasad Ram only, and thus the same was his self-acquired property. Hence, no question of partition actually arises as far as 0.97 acre of the land of plot number.
Just hold on. So the learned court has recorded a finding that it was a self-acquired property,
Yes.
and therefore there is no question of any partition. आगे बढ़े. Next, this is first finding.
Failed to adduce any evidence to show the unit of title इतना डिसमिल acre land plot number इतना खाता नंबर इतना. As the plaintiff has failed to adduce any evidence to show the unity of title to the two brothers over the suit land, whereas the defendant has deposed especially during his cross examination that partition has already been taken place between Ramprasad Ram and his two brothers prior to the settlement. Further, it is the own case of the plaintiff that Ramprasad Ram had only one daughter, namely Murkalia Devi. Even if the case of the plaintiff be taken as true, as per law of the succession, the self-acquired property of Ramprasad Ram shall devolve to his daughter and not in favor of the plaintiff. However, defendants had challenged the existence of Murkalia Devi and had submitted that Ramprasad Ram had two daughters, namely Jirva Devi and Hiramani Devi, and one from his first wife and another from his second wife. But the objection so raised by the defendant is not required to be entertained with full swing, and because this is not a matter in controversy and will not affect the main issue. Even otherwise, the plaintiff witnesses during cross-examination has admitted that Ambika Ram is the son-in-law of the Ramprasad Ram, who has been sworn as husband of the defendant number 2 in the course of title plaintiff itself, and thus the case of the plaintiff that Ramprasad Ram had only one daughter is being demolished, and on the preponderance of evidence it can well be ascertained that defendant number 2 is also the daughter of Ramprasad.
So this is another finding.
Yes.
This is finding number 1. This is finding number 2, and this is finding number 3. आगे बढ़ो.
The defendant in their claim has submitted that Ramprasad Ram out of the allotted share itna acre orally transferred 16 acre land in favor of Murkalia Devi, whereas under para 5 of their claim they themselves have contended that prior to the transfer of land in favor of the Murkalia Devi, Ramprasad Ram died. That is to say that the said oral transfer as contended by plaintiff was made by dead person, which is barred by section 5 of the
This is
legislation,
finding number 4. Next.
which provides that transfer of his whole property could be taken place only between two or more living persons. The plaint of the plaintiff itself is full of material contradiction, and the content therefore has not been duly supported by their documents been adduced by them. Further, the plaintiff had contended that the Kumarkalia Devi, after getting the oral transfer in her favor by her father, transferred her share amounting to 16 dismissal in their favor by virtue of registered sale deed number itna and put them in possession thereof. And in support their contention, they have also produced a certified copy of the said sale deed, which has been marked as Exhibit 2. The recital
So
of which
Exhibit 2 has been completely disbelieved. Correct? This is another point. And then the court goes to the Evidence Act. Section 64 quoted. Then further section 104, all these things are quoted. And then the learned court records a finding.
that certified copy is not
No,
admissible.
that is not the only finding. This
Yes.
is what I am saying.
Yes.
There are numerous other findings which have been recorded by the learned trial court. While coming to a finding at last of para number 23, that the very foundation in the form of Exhibit 2 and 4 has not been duly proved by the plaintiff. Right? Now you tell us from the appellate court judgment that these reasonings have been dealt with. दिखाइए appellate court judgment में इस reasoning का finding दिखाइए एक एक reasoning का 5 reasoning आपको दिखाए right अब सारे reasoning का finding दिखाइए
अपीलेट कोर्ट में जिसको कॉन्ट्रोवर्ट जो डिटरमाइन करेगा अपीलेट कोर्ट से उसी पे डिस्कशन करेगा
ठीक है
जो अपीलेंट जो
Exhibit 4 को डिटरमाइन कर रहा है ना
हाँ एग्जीक्यूट हो
तो Exhibit 4 से ही Exhibit 2 आ रहा है
दोनों सिमिलर नेचर का है
सिमिलर नेचर नहीं Exhibit 2 के बारे में तो बोला है कि the person had already died prior to the transaction. We have read it. You just tell us from the appellate court judgment that these reasonings have been considered. कहाँ है appellate court judgment? Yes. Point of determination आप उस दिन point out किए थे.
para 13 में है लोग
Para
13 para 13 शुरू से पढ़ते हैं
The only point required to be considered in this case is regarding rights of the plaintiff applicants. तो मतलब पूरा ही open है. Everything is open. Rights of the plaintiff's applicants.
उसी के लिए सूट ही फाइल किया
कोई बात नहीं. उसके बाद जो है आप इसका हमको रीजनिंग दिखा दीजिए ये इसके बाद ही ना रीजनिंग होगा पॉइंट ऑफ डिटर्मिनेशन फ्रेम किए उसके बाद रीजनिंग के पढ़िए
इसमें और है देयर इज नो काउंटर क्लेम एंड देयरफॉर द ओनली पॉइंट रिक्वायर्ड टू
आप
बी
पैरा 13 पूरा ही पढ़िए ठीक है यहीं से है फाइंडिंग
the second part of the land relates to
Exhibit 4 is the document of the year 1969
30. Exhibit 4 is the document of the year 1969. Ram Prasad Ram was not alive during trial and was not available to prove on controvert his signature. The document being 30 years old and would have been marked so if the original would have been produced. The plaintiff appellant has cited 2001 3 Jharkhand Itna wherein the Honorable Court has held that the certified copy of registered sale deed is admissible in evidence even if it is not proved by calling witness. Section 79 of the Evidence Act states that certified copy shall be presumed to be genuine, which is admissible as evidence. The plaintiff appellants were under duty to produce best evidence, but it was not mandatory on their part to produce the original. The Exhibit 4 has been certified from the office of the registrar to be true copy. The plea of the defendant respondent that the deed of partition was manufactured has to be examined. The plaintiff appellant has filed Exhibit 1, Exhibit 1/1, Exhibit 1/2, which are rent received for 56 decimal of land running in the name of Phagu Dosar, Phagu Ram, and has been proved by PW4 Krishna Tiwari, Devanarayan Shukla, Kokileswar Prasad. On the other hand, the defendant respondent have pleaded in para 11 of the written report that rent is being issued in name of defendant number 2 and 1, but no rent receipt of any other deed or relevant document has been filed on their behalf. The only two documents filed on behalf of the defendant respondent are the order dated Itna passed by executive magistrate Nagarutari and order sheet of revisional court. Copy of the judgment passed by the revisional court has also not been filed. Section 145 CRPC is intended to consider land, water and boundary dispute which may lead to apprehension of breach of peace, and in such proceeding an executive magistrate, if possible, can declare possession of party as on the date of the dispute or may consider disposal within 2 months prior to the said dispute. Under this provision, the declaration of possession is temporary in nature and is not based on any right or title of the party. The documents filed by the defendant respondent has very weak in evidentiary value. Exhibit 1 by 1 and Exhibit 1 by 2 corroborates the claim of plaintiff appellant with regard to 56 decimal of land obtained by Phagu in amicable partition deed number जो Exhibit 4. The learned lower court has taken hyper-technical view to discard Exhibit 4 and the consideration regarding partition being not equitable is also unwarranted. In cases of natural love and affection, it is immaterial that a person give a bigger chunk or valuable portion to his near or dear. The defendant respondent has pleaded that the defendant number 1 has received 19 decimal of land through Sada Patta. No such document has been filed on behalf of the defendant, and the property also cannot be transferred to Sada Patta. However, there is no counter claim, and therefore the only point required to be considered in this case is regarding right of the plaintiff appellant. The learned lower court has also wrongly considered section 46 of CNTF as the case of the plaintiff appellant is that Ram Prasad Ram was the elder brother and Karta of the family, and therefore his name was recorded in
Just a moment. There is a specific finding by the learned tribunal that it was a self-acquired property of Ram Prasad Ram, and therefore it could not have been subject to. If it is a self-acquired property of a member of a family, joint Hindu family, then under such circumstances you can transfer it. But that cannot be a matter of partition. This is the finding of the learned.
Yes.
Where is the meeting? Where does it meet?
फाइंडिंग नहीं है वो बोले कि उनका सेल्फ एक्वायर्ड प्रॉपर्टी अगर माना भी जाएगा वो बोलता है तो पार्टीशन जो एग्जिबिट 4 को ट्रायल कोर्ट ने इग्नोर कर दिया
ट्रायल कोर्ट ने उसको बोला है इट वाज अ सेल्फ एक्वायर्ड फाइंडिंग है कि नहीं
वो नहीं वैसा नहीं है ट्रायल कोर्ट बोला है
ट्रायल कोर्ट में है ना
हाँ ट्रायल कोर्ट बोला है
एपीलेट कोर्ट में ने इस फाइंडिंग को रिजेक्ट किया है What is the meaning of meeting the reasons of trial court judgment? If trial court judgment is based on 5 reasons, then the appellate court, in order to reverse the decree, has to meet all the 5 reasons. Once the trial court holds that it is a self-acquired property, then you please explain how can it be said that he is the karta of the family and it is subject to partition. How can that property be subject to partition? This is what we are indicating, that the reasons which have been given by the learned trial court, the only trial court has not taken a view only because of non-production of original document. There are multiple reasons cited by the learned trial court for not decreeing the suit. And our concern is that these factual aspects have not been controverted or set aside by the learned appellate. And therefore, the reasonings which have been given by the learned trial court to give its judgment has not been met by the learned appellate. So I am just calling upon you to satisfy this court that 5 reasons have been cited by the learned trial court, and all the 5 reasons show me that it has been dealt with, that trial court has gave this finding is incorrect and it does not bear from the records. And so far as Exhibit 2 is concerned, the finding is conclusive. Exhibit 2 has not been decreed in your favor, even by the appellate court, and you have not filed any cross appeal.
हम अपीलांट थे ना, फर्स्ट अपील कोर्ट में हम
आप
अपीलांट थे।
जरा देखिए पैरा नंबर 17 में, पैरा 15 में, लास्ट लाइन।
The third part relates to the 16
नहीं,
dismissal.
under the circumstances, the case of the plaintiff's appellant failed with regard to the 16 decimal of land. तो ये फाइंडिंग तो आपके अगेंस्ट में कंक्लूड हो गया।
ये तो
ट्रायल कोर्ट ने भी आपके अगेंस्ट में फाइंडिंग दिया 16 डेसिमल के लैंड के बारे में। एपीलेट कोर्ट ने भी 16 डेसिमल के लैंड के बारे में आपके अगेंस्ट में फाइंडिंग दी।
ओके,
आपने इसके अगेंस्ट में कुछ क्रॉस अपील नहीं फाइल किया है, तो 16 decimal of land which regard to Exhibit 2 has become final against you.
yeah,
Now what remains is the remaining portion of land,
56 dismissal.
56 decimal of land, whatever be the figure. Now, with regard to 56 decimal of land also, the trial court has given, with regard to Exhibit 4, 5 findings. Where is the meeting of those reasoning by the learned appellate court? The moment the trial court has come to a conclusion that it is a self-acquired property of Mr. Ram, then under such circumstances, where is the question of partition? He could have transferred it to anybody. That is a separate thing. The only reason which has been the non-production of document is not the only reason cited by the learned trial. Show us the reason. It has not met with those reasons. And that is why first question of law has been framed. After all, a question of law has been framed and we need to answer it. But has the appellate court met with the reasons given by the learned trial court by reversing the decree?
इसको सब्सटेंशियल क्वेश्चन को रिकास्ट किया जाएगा।
क्यों रिकास्ट करेंगे?
नहीं तो पहले से जो चार
बिल्कुल सही लिखा है सब्सटेंशियल क्वेश्चन ऑफ लॉ।
देखा जाए, सब्सटेंशियल क्वेश्चन को भी एक बार देख लीजिए।
देख लीजिए, पहला सब्सटेंशियल क्वेश्चन ऑफ लॉ देख लीजिए, रिकास्ट का कोई बात ही नहीं है।
फर्स्ट होगा तो फाइंडिंग ऑफ द
एग्जिबिट ए तो गलत ही लिखा हुआ है, एग्जिबिट ए का कोई
इसको तो
मतलब
करेक्ट किया जाएगा।
ठीक है, आगे बढ़िए।
Whether the learned court of the appeal below has applied correct principle of
नहीं,
law,
ए पढ़िए, क्वेश्चन ऑफ लॉ ए।
whether the finding of the learned court of the appeal below on exhibit A,
एग्जिबिट ए नहीं, एग्जिबिट 4 होगा ये।
a true copy of the partition deed and as a consequence thereof reversing the judgment and decree of the trial court partly and thereby decreeing the suit in part even without meeting of the reasoning of the learned trial court is legally and factually sustainable.
Yes. This is the first question of law.
There are two parties, lordship. Plaintiff come with prayer to declare his right title and produce the document exhibit 4, which is basis of getting the land through partition 56 decimal land का। Subsequently जो 56 decimal land ट्रांसफर हुआ उसका म्यूटेशन किया गया, उसका रेंट रसीद मेरे नाम से इशू होता है लॉर्डशिप। बोथ डॉक्यूमेंट इज
आप क्वेश्चन नंबर ए से भटकिए मत।
हम भटक नहीं रहे।
हम सिर्फ एक ही सवाल पूछ रहे हैं और आखिरी बार कि एपीलेट कोर्ट ने जो पांच रीजनिंग ट्रायल कोर्ट ने दिया है विद रिगार्ड टू एग्जिबिट 4, whether the appellate court has met with that reasoning. The trial court has given a specific finding that it was a self-acquired property of Ram. Finding is there. We have read it. Is there any finding that this finding is incorrect? Yes. There is no finding. अपनी तरफ से एक जजमेंट देने से थोड़ा civil law proceeds in a different manner altogether. You cannot have two parallel findings, one by trial court and another by appellate court, and second appeal will decide which one is correct.
If all the evidences is on record, no further evidence is required, so why the case will be remanded?
That is the law. आप देखिए वो जो हम आपको जजमेंट दिए हैं उसमें तो सारे सुप्रीम कोर्ट के जजमेंट सारा कुछ साइड किया हुआ है।
ये जो
और पहली बार सेकंड अपील में क्वेश्चन ऑफ लॉ डिसाइड होता है, यहाँ पे क्वेश्चन ऑफ फैक्ट नहीं डिसाइड होता। वी विल नॉट डिसाइड whether which of the courts have come to a correct finding. ऐसा कोई क्वेश्चन ऑफ लॉ भी फ्रेम नहीं हुआ, and I am not supposed to decide anything beyond the question of law. ऐसा कोई क्वेश्चन ऑफ लॉ ही फ्रेम नहीं है कि दोनों में से कौन सा फाइंडिंग करेक्ट है, ना ही कोई ऐसा क्वेश्चन ऑफ लॉ फ्रेम हो सकता है. दैट इज नॉट द स्कोप ऑफ सेकंड अपील.
फिर हम उसको ये को पढ़ते हैं. ये टू कॉपी ऑफ द पार्टीशन डीड एंड देयर कॉन्सिक्वेंस देयरऑफ. ट्रू कॉपी पर जो लोअर कोर्ट ने बोला है एंड उसका कॉन्सिक्वेंस दैट इज द म्यूटेशन रेगुलर रजिस्टर दैट इज इट्स कॉन्सिक्वेंस.
आपको हम सुन लिए हैं, ठीक है. तो you may have remedy somewhere else, but I'm not satisfied so far as question number 8 is concerned. What do you have to say with respect to question number 8?
क्वेश्चन नंबर बी पे टू कॉपी ऑफ द पार्टीशन डीड एडमिसिबिलिटी पे जो फाइंडिंग दिया है, तो एडमिसिबिलिटी पे हम जजमेंट देते हैं लॉर्ड. ये सुप्रीम कोर्ट का सिविल अपील नंबर 14660.
पैरा नंबर बताएंगे. What was the issue involved? What was the point?
The para 29 onwards लिखा है लॉर्ड.
पैरा नंबर 4
29 onwards.
पैरा 4 पहले तो बिना फैक्ट के कोई जजमेंट नहीं पढ़ा.
केस लॉ तो लॉ है ना, फैक्चुअल है.
जो पॉइंट फ्रेम होता है उसी पे केस लॉ चलता है. पासिंग रेफरेंसेस से केस लॉ. पैरा नंबर 4 is the issue framed by the trial court. An additional issue was also framed. Then
whether the sale deed of the plaintiff is forged, whether the mortgage deed number इतना is genuine, whether the sale deed number is genuine, whether the entire superficie is not under the.
इसका पैरा 9 में आइए, इंटरनल पेज 9. उसके बाद स्कोप ऑफ सेक्शन 100 को डील किए हैं, ठीक है. उसके बाद संतोष हजारी का केस है. व्हाट इज द मीनिंग ऑफ सब्सटेंशियल क्वेश्चन ऑफ लॉ.
Santosh Rayal perhaps
उसके बाद आइए
has been dealt in your ladyship judgment. In second advertise
पैरा जस्ट पैरा 14 में आइए. पैरा 15.
The point of law which
पैरा 15 इंटरनल पेज 14. ठीक है. 100 में सेक्शन 100 में पावर एक्सरसाइज करके डिक्री रिवर्स किया गया. That was the matter before the Supreme Court. हाई कोर्ट ने कौन से इश्यूज फ्रेम किए? पैरा 16 में है, ठीक है. उसमें से कोई भी इशू एविडेंस एक्ट से रिलेटेड नहीं स्पेसिफिकली, ठीक है. उसके बाद आई
तो पारा 17 में देखा गया.
हाँ पैरा 17 पढ़िए.
Exhibit A1 इसका वो फर्स्ट रोमन A1 सेल being dated is not produced as an answer P1 is this appeal was executed in favor of the William Kaladi by sons of Belia. However, no document was produced by the plaintiff. The appellant hearing in fencing as to how they obtained it under partition so as to have right to alienate it. Exhibit A1 would not attack the presumption of genuineness provided under Section 90 and presumption proof of ownership under Section 110 of the Evidence Act for the reason that it is only a registration copy of the registered sale deed. And its genuineness is disputed. Furthermore, in the light of the decision in R. Nair Pillai and others, to admit such document in the evidence and to presume it as genuine is required corroboration by an independent witness. Exhibit A to would not stop under section of the
Yes,
next
I
the court below did not place reliance on the exhibit B1 certified copy of the sale deed dated in the executed by the appellant's father and Perumal Nayakar, mother of the plaintiff, in favor of the Homi Nayakar, and extent of 52 cents from the suit property with implication. Entitled only 96 dismissal. With the factual expectations here.
उसके बाद
In the light of
the reasons.
in the light of reasons that the persuaded the High Court to reverse the concurrent judgment as mentioned above, their sustainability is to be looked into with respect to the positions of law as noted herein above. With respect to the scope of exercise of power under section 100 CPC and with reference to the relevant provision under the Evidence Act as also other relevant enactment, we will consider whether the High Court was legally correct in the holding that owing to the non-production of any document by the plaintiff evincing as to how the sons of Beliate obtained the suit property in the partition exhibit A1 being a registered copy, secondary evidence could not be admitted in evidence as proof of the contents of its original. At the outset, it is to be stated that while holding thus, the High Court has failed to consider the relevant provision under the Evidence Act and also the Registration Act 1908 appropriately. If the relevant provision under the said enactment were properly applied to the fact of the case, the High Court could not have placed reliance on R. Nayar Pillai case, Supra, to hold that since Exhibit 1A1 being a registration copy, the presumption of due execution of the original under Section 90 of the Evidence Act, particularly in the absence of independent witness, would not be available. We say so because proper consideration of the provision under Section 61, 63, 65, 74, 76 and Section 79 of the Evidence Act would have definitely brought out that it was absolutely unessential to consider the applicability of Section 90 as also Section 110 of the Evidence Act. Needless to say that in such circumstances there would not have been any necessity to seek proof through an independent witness as well. At the outset, it is very much relevant to note that the finding of fact by the trial court that Exhibit 1 and Exhibit 5 are all registered with sub-registrar office was not disturbed, rather agreed by the first appellate court. As a matter of fact, the High Court also did not reverse the said finding on the fact. Indisputably, the appellant has produced the registered copy, Exhibit A1